next motion is defense filed a motion that Jasmine Pace not be referred to as a victim throughout the course of proceedings and throughout the trial, and that she be referred to either by name or by proceedings. The state has produced case law that says that it's basically judicial discretion. There's 2 or 3 cases I found on it where the Court of Criminal Appeals found that the trial court did not abuse its discretion by refusing to refer to the decedent, or whatever you want to call it, as the victim. So there is nothing more than just asking this court as the gatekeeper of evidence to use your discretion. And we ask the court that this case would be referred to as Jasmine Pace or the decedent.
This is, my understanding of the case law is that the problems come when there's a dispute on whether or not the victim was actually a victim, whether it's a self-defense case, whether it was simply an accident. I don't think the defense is arguing that a murder did not occur. So I do think that in this particular case, based on what the case law I've read indicates, the issue that prevents a person, or that should prevent a decedent being referred to as a victim, isn't present in this case. Does the state want to be heard on that? Or?
Your Honor, to the extent that the state would refer to Ms. Jasmine Pace as a victim, that's a theory of the state's case. We submit also that the jury would be instructed, following such comments, at the conclusion of all of the proof, before they are charged to begin deliberation, that comments and statements of counsel are not evidence, that they are the triers of fact, or that they are the ones to decide whether the defendant is guilty of the crime of murder.
Okay. All right. Anything else to add, Mr. Weiss, on this motion? Motion overruled.
The next motion was the law enforcement with Hamilton County and I believe it's the Nolensville Police Department executed a search warrant in 1942 National Court in Nolensville, Tennessee. During the course of their search, they took pictures of, I believe it's the desk in the bedroom of Jason Chen. And some of those have notes that we believe are protected by attorney-client privilege. And also, we also argue that they are not relevant under 403. And they don't have any probative value, and it's overly prejudicial. And I have those pictures ready to show the court.
State will be heard.
Your Honor, the state would submit that there are certain portions of the photographs which will be shown here shortly. I also have them printed.
Oh, here.
Yes. Your Honor, I think by the agreement of the parties, we would submit photographs in question with the exception that the state has placed proposed redactions to material that we think would be objectionable, specifically, I guess, notes that you would describe as possibly statements about conversations with possible counsel, dollar amounts, it looks like. So we would submit this as a collective exhibit for the court's consideration.
Okay. I'd like to exhibit 1 for this hearing then.
And in light of the redactions, Your Honor, we would submit that it's not objectionable, it's not unfairly prejudicial.
Yes, sir.
I can provide these in digital format if the court finds it difficult to read.
You can refer to them if you've got a copy in front if you want. If you want to put them on the screen, just to make sure I'm looking at the same post-it you are. So we'll do that. On the defense laptop.
Yes, please. so this is the unredacted version, which is different than what the court has in front of it. Some of these notes have conversations or notes that we believe that the defendant has written and after having conversations with potential counsel, and we believe that's what all these notes are relevant to. So based on that, we would ask for all of the pictures of these notes to be excluded in total. If the court, otherwise, in the alternative, we'd ask the court to go through each note and choose which ones to redact if the court finds it in violation of Rule 403 or if it's protected by attorney-client privilege.
So, General, to understand you, the redacted aspects are aspects that the state agrees should be redacted, or?
Yes, Your Honor, and if we could, I guess, zoom in on, for instance, on, go to 276, Judge. Next one. One more. Yes, Judge. So if Your Honor were to draw your attention to the purple note towards the center of the screen.
Yes.
And Josh.
My copy's redacted.
Correct. And if Josh, what would you like to? Your Honor, it's got a phone number there. I recognize that to be a phone number of counsel. I don't know that it would necessarily mean anything to a layperson looking at the evidence, but in abundance of caution, the state did black that out because it is, I guess, indicative of somebody reaching out to an attorney.
I mean, if the state agrees that the blacked out portions should be redacted, we can just talk about the things that Mr. Weiss thinks should be redacted and the state doesn't. So I guess we'll go through it post it by post it then.
Yes, sir. The first picture here is, I think, just showing all the notes, and then in the subsequent pictures, you can see individual notes.
Okay.
Here, the one that's labeled right hand, I don't know what relevancy this would have to the case. Obviously, it doesn't have any attorney-client privilege information, but it's not
Relevance is a pretty low burden.
There's one more here.
I mean, the simple fact that they're organized notes that have something to do with his life at the time, in context with these other notes. Apparently your client thought it was relevant. So again, 401 and 403 is a very low threshold.
Yes, sir. The note here on the, that's next to the purple note,
Hang on just a second. Is there a photo? All right, I'm looking at page 3 of Exhibit 1.
it says she has a long history of running away from her parents. I believe that's in reference to Jasmine Pace. I know relevancy is a low bar, but I believe that's overly prejudicial and it's not relevant.
If it has anything to do with the case in general, has some bearing on a consequence, has some consequential bearing upon fact that's material, and the danger of unfair prejudice does not substantially outweigh the probative value, then it should come in. And I don't see where the danger of unfair prejudice applies to that note.
Yes, sir. Above that, you see where it says Crawford and the phone number. I believe that is the phone number for the lead investigator in the case. Is that Crawford?
Okay.
I think that's overly prejudicial.
particular case?
Yes, sir.
Clearly, the lead investigator to the case has some relevance to this particular case. Overruled.
In this, I don't have the redacted copy in front of me, but in the upper left-hand corner, we're on the next page, Judge.
Okay.
It says, I need a legal, is this the redacted form? I need legal consultation, a potential suspect in a suppression case, and it says, I know I'm, let's see.
I got a pretty consistent I-N-N-O, so you presume it says innocent, or would have said innocent, perhaps.
Asking for that to be.
What does invoke getting a lawyer, general? I mean, it's not, I suppose the analysis is whether or not it's privileged.
That is indeed the question, Your Honor. It reads more of a script of what he intends to tell somebody. It's not a privileged communication in and of itself. I would submit that on the note to the right, there is a name. It says Ben McGowan, which the state has agreed should be redacted. I think that's a misspelling of a local attorney here in Chattanooga, which, again, I don't know that jurors from outside of the county would have any inkling who a Ben McGowan is, but I would submit that the note on the left is extremely appropriate. It's not my lawyer told me 1, 2, 3, 4, 5. It is rather a script. It's a statement by a party opponent.
It seems to me that a fair interpretation of the note in the upper left, again for the record we're talking about, page 4, exhibit 1, the note in the upper left, seems to be a script of what Mr. Chen would have told his attorney. I think it's borderline. It probably does not qualify as a privileged communication because he's not saying that to his attorney. But I think it's a fair interpretation of something he would have said to his attorney. I'm inclined to grant the suppression of that upper right, upper left, because it does seem to be pertinent to getting representation. I think that's a little too close for my comfort, so with that, let the defense motion to redact or suppress that particular upper left note on page 3 be sustained.
The next note directly below it, I believe, is a continuation of that same script.
I think that that's more arguable. I think that that's something that could have been written. It's less clear that that was written in preparation. I think the upper left note taken in context with the one in the upper right is clear. I think the lower left note perhaps taken in context, it might be a script that he was going to talk to his lawyer about, but since the upper left note will be kept from the jury, I don't think the lower left So, again, my copy is redacted. Ben McGowan. It's the top right.
Your Honor.
Okay. I'm looking for the lower right, but
This-
7,500.
The state has redacted this part of it, but this part here is just a statement of law.
We think, gentlemen, that's something where I suppose the argument could be, you got that off the internet, but taken in context. It's
Sure, I
like-
think it also goes to guilty conscience, Your Honor.
Go ahead, I'm sorry.
I'm not quite sure how that would show. I would need an explanation of that, how that would show a guilty conscience. And I can say those two things objectively, and that have no bearing or relevancy to this case.
I think a fair reading, it might have come from conversation with an attorney who has been McGowan or attorney. It doesn't seem like something that, I mean, that's correct. Maybe it's not a hearing in 14 days. Perhaps that's something you could have gotten off the internet, but taking the context of the others, go ahead.
I would submit that he has not been arrested yet, Your Honor, so he's clearly contemplating that that is going to happen, that he has a guilty conscience, and obviously when taken in context of that note that Your Honor's ruling on it says that I think he's acknowledging how this is, that in fact, there is evidence that shows that he is guilty of crime and therefore will be arrested.
No, it's just basically, this is a statement of law, like entitled to a hearing in 14 days. It's a preliminary hearing, police have to show probable cause. It doesn't seem more of a statement of fact. Any response to that? Other than what you already said?
No, Your Honor.
All right, the defense motion to suppress the lower right note on page 4, be sustained. Page 5.
This next picture is the posted note with the name Ed McGowan, but it's the full note. I think the court has noted that that's admissible for other reasons. And then here in the lower right-hand corner, you'll see another note that we've seen on the next photograph. It says, talk to her mom on the 26th. Premeditation, death threats, breaking and entering, and missing person yesterday.
I read that saying defamation.
It does say that.
Seems to me that's, again, speculative guess, but might be what negative aspects of his situation might be. He's getting defamed, getting death threats, perhaps. What do you think? That change your analysis where it says premeditation versus defamation?
Either way, I didn't think it was relevant.
General, what do you say?
Your Honor, I submit that for the same reason the court found statements about Saturday, November 19th, last time I saw her. Again, it's a submission by party opponents. It also corroborates certain pieces of evidence. In this case, Your Honor may recall during the motion to suppress Officer Pierre's body cam video, where there's a telephone call between Ms. Trina Pace and this defendant, that this note right here, I talked to her mom on the 26th, that corroborates that that was indeed his voice. So that makes it extremely relevant.
I agree with you with the top part of the sentence. I'm talking about the second part with the defamation, death threats.
Sure. Your Honor may also recall that there was testimony by Investigator Crawford that the defendant's cell phone placed him in the area after the search by the Pace family. That indicates and corroborates the fact that he was in fact there. If he did not return to his apartment, how would he have known of breaking and entering? Furthermore, Judge, one of the recordings that the state has in its possession, which the defense also has in its possession, is a phone call, again, recorded, where the defendant is complaining of people threatening him. So I would submit that on that, under 403, it's not unfairly prejudicial. This corroborates and identifies him in other pieces of evidence.
I think the top part of the note definitely comes in, but the second part seems that it might be something that his attorney instructed him to do, or talking to an attorney, I guess either Ben McGowan or someone else. I don't know if Mr. Chen would have gotten defamation, off the internet, but it seemed like something a lawyer might have told him. So let the defense motion to suppress the bottom half of the bottom right note on page 5 of Exhibit 1 be sustained.
You mean top right? I don't know how you're.
Like this bottom right, the defamation. Oh, I was looking at page 5.
It's the same note that you're looking at, it's just the full map.
So I guess looking at page 6, yes, looking at page 6 of Exhibit 1, it would be the top right note. So let the first sentence should come in, talk to her mom on the 26th, but the line below, defamation, death threats, breaking and entering, the defense motion to suppress that one statement be sustained. And I wasn't looking at this bottom line. It says missing person yesterday. Either side want to provide more information other than those 3 words.
That's all we got.
Never.
That seems to be less legal, what comes from a lawyer, and more something he might have gotten from following the news. So the only thing that will be suppressed on that top right note will be the middle line, the middle entry of defamation, death threats, breaking and entering.
The note below that, Your Honor, the state has agreed to redact the top portion of it where it says the name, the phone number, and the address, and then the number of the circular in the middle. However, you can tell from the context of this note that this is a conversation with this attorney. And the notes that are contained are obviously notes from the conversation.
See if I read it correctly. It says November 19, last time I saw her, she would call me. Last time was on, she would call me once a day. Last time was on November 22nd on phone. That seems more in line with the other notes that came from Mr. Chen that have already been ruled admissible. Seems more in that line, Mr. Wise. Anything else you want to say about that one that hasn't been said?
So, otherwise, the state's redaction is just an agreed upon, and the rest of it's listed. And then, here's the last one. This is a note in a notebook. You can see the name at the very top of the McGowan and his phone number.
This is page 7 of Exhibit 1. See, Friday, November 18th, last time I saw her, Tuesday, November 22nd, last time we talked. She has a huge history of running away from home in her teenage years. Mom was an alcoholic, ran away, let's say, to Canada for several years, and was homeless. Trying to see if anything under the strictly through language is legible, so if something has a restraining order against her ex. clearly.
redacted a portion at the top, so we obviously agree with that. We asked for a portion redacted.
As with these other notes that have been brought to the court's attention about Mr. Chen's interactions with the victim, it seems this falls in that same category to the defense motion to suppress the notebook entry on page 7, Exhibit 1B overruled.
And then, Your Honor, there's, sort of going back to like the first picture of it, there's a picture of all the notes. So I would ask that the portions that the court has ordered to be redacted and the partially redacted by agreement of the parties be redacted on all copies shown in the picture.
Okay.
Yes, Your Honor.
I'll submit the proposed redactions this evening.
This motion also references a video. Oh, I'm sorry.
That motion references it.
I'm looking at the one with the search warrant. The style of motion looking to exclude defendant's statements and video. Is that something different than?
Yes.
Okay.
So I'm just to give the court some context, the defendant was arrested at his parents' residence in Owensville. There was one officer that had a body camera that captured it. It is not an official like interrogation, I would say. However, there is no question that the defendant is in custody, which the state agrees with. The relevancy of playing this video, or there is no relevancy to playing this video. It's overly prejudicial. There's a waste of time, and I don't want the court to get into it in front of the jury. The video is about an hour long, but I believe it's only the first 20 minutes, 25 minutes. That is relevant.
Gentlemen, before we play the video.
The state reserves argument.